What's going on, everybody's blessing. Welcome to Family Court Unfiltered. I'm JL Casey, and let me tell y'all why I started this podcast and why I think y'all should stick around, okay? First and foremost, I'm a father. I've been through the family court system, not for one case, not for two cases, but three completely separate, different cases, okay? So I was exposed to this by force, not by choice, but I chose to learn. Not at first, though. I used to get my ass handed to me by the family court. I'm talking about handed to me. I still go through battles now. I'm not exempt. But I tell you, it's a lot smoother on my end. I mean, I've had attorneys. I've been pro se, but I had no knowledge all three times. So I started studying the law, the statute, the rules and procedures, and I actually started to get some wins in family court. Now, I'm not saying this to brag. I'm saying this because it took me over 10 years of learning the system the hard way to actually find out what works, but really, more importantly, what gets parents destroyed in court. All right? And here's what I've learned. Family court does not work the way you think it does. It does not care about your feelings. It does not care about what's fair. It doesn't care that you think you are a good parent. You could be a good parent. It doesn't care that you had good intentions. Family court is a civil administrative system. It rewards procedures. It rewards documentations. It rewards credibility. And it's going to punish the parents who do not understand that, okay? That's why I started this podcast. Every episode, we're going to tackle another specific myth or mistake that parents make in family court, okay? I'm talking about the stuff that sounds really, really good on the internet, but will get you wrecked in the courtroom. Things like thinking, I know my rights, so that's going to protect me. No, sometimes it won't. Or thinking you can just pay the other parent directly and just call it child support. No, sometimes you can't. Or believing that if you terminate your child support, the arrears just going to disappear. Listen to me. A lot of times they will not, okay? I'm going to give you the real case law, the real statutes, okay? I ain't talking, we not doing none of this sovereign citizen stuff, none of this TikTok legal advice that done gone viral, because that stuff will get you held in contempt, okay? This podcast is for parents in custody battles or even parents dealing with CPS battles, from child support to anything family court related. Whether you're representing yourself pro se or even if you have an attorney and you just want to understand what should my attorney actually be doing for me, okay? So I run a legal consulting business. Now it's called Child Support Victory Consulting, okay? I help parents across the country navigate these exact situations. I wrote a book on it. I've helped numerous of parents avoid these same exact traps that I'm going to teach you about on this podcast, okay? So here's what you can expect. Every episode, we're going to hit the same foundation from a different angle. Different topic, same lessons. Family court reward structure, not sentiment. I need y'all to understand that. So if you want to win and you need to understand how the system actually works, all right, that's Family Court Unfiltered. Y'all, let's get into it. We got a lot of screens to pull up, so y'all bear with me. All right, parents, we got a lot of screens up. We're going to get into it. But listen, if you ever walked into a CPS interview or a family court hearing and you're in there saying, oh, I know my rights, you probably have made things worse. Not because you were wrong about your rights. Yes, you have rights, but because family court does not work the way the internet told you it does, okay? Today, I'm going to explain why those constitutional slogans, they don't really land in family court the way you think they should. And I'm going to explain what actually protects parents. So I'm JL Casey. This is Family Court Unfiltered, all right? How the system actually works, not how people think it works, okay? This is education. None of this is legal advice. This is all educational, okay? So y'all, let's get into it. All right, parents, we got a lot of different screens up, so we're going to get into this like a study session. So y'all bear with me. I am new to this. I am not true to this just yet. So like I said, y'all bear with me. So again, so why these topics matter? It's because every day a parent loses credibility because they learn some strategy from a Facebook group or a TikTok viral video, and they're trying to utilize it in court. But I mean, the advice sounds really empowering, but a lot of it is built on criminal court and not family court. And there is a big difference in the two. So by the time they realize that it really doesn't work, they've already been labeled as uncooperative or fictitious litigant. We really don't want to get into that. So when parents usually get it wrong, they're thinking that constitutional rights are going to trump everything in family court. And again, that's just not the case. So they get into treating CPS workers like they're the police when they have two different set of rules to abide by. So they believe magic words or scripts are just going to shut down an investigation entirely. That's not the way it works. Parents, we got to get into what's really truth here. So a lot of things are at stake. First of all, being written up as an uncooperative or hostile parent, fictitious litigant, we can get fines placed on us. We want to avoid that. Okay, let's avoid being called uncooperative or hostile. So you got judges forming negative impressions on you before you even speak. And I know you feel like that's unfair, but like I told y'all at the beginning, family court doesn't operate on what's fair and what's unfair. Okay? The sooner y'all understand that, the better. And then we got losing our custody or visitation rights over perception versus facts. So we have to learn how to get our facts onto the record without being perceived as some fictitious litigant striving to stand on our rights. Again, you have rights, but you got to know how to apply them in family court because they hold different weight from court to court. Got to understand that. So we're going to try to we're going to try to touch base on some points. And one of the main points is that family court operates on a completely different standard than criminal court. Okay? So listen, the principle is that family court requires beyond a reasonable doubt. All right? I know a lot of y'all understand that phrase. So that's pretty much saying that I need to believe this within at least 95% or more, that this is accurate, okay? Versus family courts, they operate or uses preponderance of evidence, all right? So this is more like a 51% type of thing. If the judge just has a 51%, then they'll kind of swing that way. So that means you can be completely innocent and still loses if the judge finds the other side just slightly more believable, okay? So that's how it works. We're going to get into the case laws. We're going to try to break these down and what they actually mean. But before I do that, we need to understand what case law works for you because every single case law is not going to work in every state, okay, every jurisdiction. So we need to understand, we need the hierarchy of the situation. Let me break down the court hierarchy for y'all. Let me try to explain it because there's a difference in them, okay? So I want y'all to think of the court system as a ladder. Think of it as a ladder. All right. Cases end up starting at the bottom and then they work their way up. Okay. So the higher the court, the more authority that court has. Okay. The more authority that decision is going to carry in your court, in your situation. Okay. So we need to understand the ladder. I'm going to try to bring it from the top to the bottom. All right. Or to the top. So the bottom, you would start at the trial court. Okay. So what trial court is like, this is where it starts. You end up having one judge. Okay, you can end up having witnesses that can testify. You bring evidence that's presented, and sometimes you'll have a jury. All right, and facts are decided here at the lower court. That's trial court. That's where it's going to start. Then you got in the middle area. You're going to call this the appellate court or the court of appeals. Okay, this reviews the court decisions for like legal errors. And that's kind of a key. It needs to be legal errors or some due process violations that you're going to be able to get it into the appellate process. Now, this is a panel of judges, usually about 3 judges. Okay, so the lower court, you had one judge, you got witnesses, you got a jury. Not at the appellate process. We're not bringing witnesses. We're not doing all that. You're going to have a panel of judges, like I said, usually 3, no witnesses, no jury. We talking straight legal arguments. We talking case law, what this statute say, that's the appellate process. We talking straight legal talk, all right? None of that, what you think, what you feel. Let's talk case law and legalities. I hope I'm saying that right, okay? And then you have the top court, the very top, that's the Supreme Court. So this is the final words. This reviews appeals on major legal questions. So it reviews appeals on major legal questions. Their ruling is law. There is no higher ruling than the U.S. Supreme Court. They the big dog. What they say is stamped. You can take U.S. court and utilize it in any court, just about. We'll get into that. I don't want to jump the gun. So, okay, and then you got two different court systems. Okay, so there are two separate court systems, and they're kind of running side by side. So, first of all, you have the federal courts. All right, they handle federal law. That's constitutional issues, cases between state. The U.S. Supreme Court sits at the top. Okay. And then you have state courts, again, that handle state laws, including most family law cases are in state courts. Okay. This is a state situation. Need y'all to understand that a lot of y'all are taking y'all battles to the federal system when family court is a state issue. Now, can you reach the federal situation with this? Yes, you have a handful of cases to have. A handful. Need y'all to understand that? A handful. Maybe two. Three cases of family court that's actually utilized in the U.S. Supreme Court. I think the Turner versus Rogers. We'll get into those and how they relate to family court and possibly your situation. So again, you got the federal courts and then you have the state courts, all right? Most family court cases are in state court. But the federal cases like Turner v. Rogers from the U.S. Supreme Court, they can set rules that all state courts must follow on a constitutional issue. So if something comes up with your rights or constitutional, you can go to Turner v. Rogers and see what they were talking about as far as your constitutional rights. And we'll get into that. We'll get into that one thing at a time. And I don't want to dig too deep into this but this is the foundation. This is like I say, episode 1 about why you know your rights could get you, saying that in court could get you in more of a pickle than it could actually help you. But again, we need to understand the foundation of how to utilize case law, how to utilize the statutes, how to understand what federal court is and what the state court is, okay? So, all right, let's get into some abbreviations. So when you're looking at federal court decisions, you know what you're looking at. So like I say, the U.S. Supreme Court, that's the top. If you see U.S., that's just the United States reports. That's going to be your Turner v. Rogers 564 U.S. 431 2011. You got S.C2, and that's just Supreme Court reporter, all right? That's going to be the Turner v. Rogers 13 S.C.T. 2507 2011. Then you have L.ed.2D, okay? That's the lawyer's edition. So, example, in that case law, would still the same case, Turner v. Rogers 180 L.ed.2D 452 2011, okay? These are all the same case. It's just published in different books. Okay, that's the only different abbreviation when you get to the U.S. Supreme Court. It's just that they run out of space in this book, so they put it in that one. They're just different books, same case. Okay, when you see any of these, it's just the United States Supreme Court. So that's the highest court in the country. All right, and then you got the Federal Circuit Courts of Appeals, and again, this is the middle level. So F, that's Federal Reporter, that's the first series. F.2D, Federal Reporter, second series. F.3D, Federal Reporter, third series. The 2 and the 3D just means which set of books. So these laws are different sets of books. So remember the letter, you got trial courts, appellate courts, Supreme Courts. And we're going over the abbreviations of what they are. So the federal circuit map, the country is divided in 13 different circuits, all right? Each circuit covers a specific set of states. I'm not going to get all into that because, again, maybe we'll have an episode that just breaks this down. I'm just trying to let y'all understand how this works, what case law and what things could work for you, because a lot of times y'all are using the wrong information for your jurisdiction. They don't align. So we're trying to knock out some of that. So then you got the state court citations, all right? Many state court decisions are published in the regional reporters that cover multiple states, all right? Regional reporters. So their abbreviation is like SO.2D, SO.3D. That's Southern reporters. That'll be like Florida, Louisiana, Alabama, Mississippi. Then you have N.E.2D slash N.E3D. That's the Northern Eastern reporter. So that's Illinois, Indiana, Massachusetts, New York, Ohio. And then you'll have different abbreviations for each one. Then you got state specific reporters. Some states also have their own reporters. Okay, so again, a lot of these are just different books, but you need to understand the abbreviation because you can't. We'll get into it. All right, so you got NY.2D/NY.3D. So that's New York. That's the Court of Appeals. So that's going to be their highest court in New York. You'll see it under the Court of Appeals. And then you got AD.2D, and that's the appellate division. That's the mid-level appeal. So they got different levels of appeals as well. But again, the Supreme Court is the highest. So then you got Cal.APP.2, and that's, again, it's more to it, but that's California. That's the Court of Appeals, mid-level. And you got Florida, FL. That's Florida. That's the Supreme Court. That's the highest. So it's just a bunch of different books and reporters. It's the same within itself, but you need to understand which one specifies yours. So, like, let's say I'm Florida specific, so my home state. So, since I'm based in Florida, we go give y'all some structure. All right. So you got, again, understand the court level, but understand in your state, you'll have your own trial court. You'll have Florida Appellate Court. You'll have Florida Supreme Court. Okay, so it's the highest in your state. Yes, the U.S. Supreme Court covers all states, but you need to understand. I'm sorry, I can't stress this enough, bro. Child support is a state issue, so understand how it regulates state. You have to understand this. Okay, hey, I done got off track. I forgot which said not what I'm going over. That's but what I go over after this. Again, y'all, I'm new to this. I ain't true to this just yet. But anyways, let's try to get over this pre-introduction. And I didn't think this through. I'm trying to get the videos in 30, 45 minutes. This one may be a lot longer because I really want y'all to understand the foundation and understand how to use case law, how to use statutes, because you can utilize it and win your situation. You really just have to know how. So again, I'm in Florida, so it's like this. So we got the Florida Supreme Court. So you'll see the abbreviation, that's FL.ORSO.3D. Okay, this is the highest court. This has the final word on Florida law. Okay, in my state, yours would be different. Look it up. Okay, and you got the District Court of Appeals. That's DCA. So the abbreviation would be SO.3D. And you'll see a lot of them that has DCA. They'll let you know that it's from the District Court of Appeals. It'll be abbreviated like that. But that's the 5th district. So this is mid-level appeals. Most family law appeals end here. Most of them. It's very rare that a family court goes to the Supreme Court. It's very rare that courts make it, I ain't gonna say rare, for DCA. But for the Supreme Court, you got Turner v. Rogers. There's another one. There's like 2 or 3 that actually make it to the Supreme Court. So we think about federal issue bro, child support is a state issue. I can't stress it enough, okay? All right, so then you got the circuit court. They're not usually reported. Trial courts where family cases are heard. You got 20 different circuits. They usually don't have reports on it because if something wrong, it's one in a higher court. Then you got county courts, and these are not usually reported either. The lower trial court, small claim, minor matters. Minor matters. They make a case law based on something small because there's usually something higher that's already controlling. So Florida got 5 different district courts of appeal. Okay, you got the first DCA, that's Tallahassee, Panhandle, North Florida, everything in that area. Then you got the second DCA, that's like Lakeland, covers Tampa Bay, the Southwest Florida. Then you got third DCA, that's Miami, covers Miami-Dade, Monroe, stuff like that. Fourth DCA, West Palm Beach, covers that Southeast Florida. Then you got the fifth DCA, that's Daytona, covers Central Florida, all right? Hope I'm not losing anybody here. If I am, just rewind it, slow it down. I'm trying to educate y'all. So this is a big one. Binding versus persuasive authority, all right? This is like the most important concept for understanding why case law really matters, okay? So listen, binding. What this means is it comes from a higher court in your chain of command, all right? They must follow binding case law. They have no choice but to follow that, okay? Then you have persuasive case law, okay? This comes from outside your chain of command. They can consider it, but they do not have to. Okay, they don't have to consider persuasive case law. So if you see some good case law in California, think you're finna utilize it in Florida, it's not gonna work that way. Okay, okay. So for Florida Circuit Court judge, okay, hold on. But let me break down the chain of command. A court is only bound by courts directly above it or in its own system. All right, we need to understand that. So for Florida, I'm just giving y'all Florida, the same will relate in every state. You just have to look up your state laws. I'm sorry, we'll dig into a few states maybe, but I'm giving y'all Florida because I understand that like pretty easily. All states can be learned. The rules can be learned, hard to apply them. Like I said, I work with parents across the world, Craig. So for the Florida Circuit Court judges, they must follow U.S. Supreme Court. Again, this is the biggest in the country. If it's a U.S. Supreme Court, it has to be followed. I don't care what state you are in. All right? That's going to be the only scenario for that. All right, so for Florida Circuit Court, the judges follow the U.S. Supreme Court, the Florida Supreme Court, and their DCA, okay? They should follow, all right, other Florida's DCAs unless it conflicts with their own DCA orders. Okay. Hope I'm not losing anyone. Yeah, they may consider other states, federal circuits, law review articles. These are from other places. They can, they don't have to. Must, should, may. All right. So let's do California. So California must follow. Which one is first, y'all? The U.S. Supreme Court. This is everywhere. Everybody has to follow the U.S. Supreme Court rules, all right? And then they must follow the California Supreme Court, all right? And then their Circuit Court of Appeals. They may consider Florida cases, but if they're not binding. They don't have to go off Florida cases, okay? They don't have to do that, all right? So for a California trial judge, okay, we just went over that, all right? So again, we don't want to, you got to understand what they must do. So we're gonna try to break this down and we go try to keep it pushing with the podcast. All right. This is the podcast, but y'all need to know this type of stuff. So, all right, the court's decisions. U.S. Supreme Court, all courts in the country. Okay. Ain't no persuasive law for this. It's mandatory. All right. Federal Circuit Court. All right. That's like the 11th Circuit, something like that. All federal courts in that circuit. Okay. It's binding on them. All right, what's persuasive for the Federal Circuit Court? Other circuit courts, state courts, okay? Florida Supreme Court. All Florida courts are binding by this. What it could be persuasive to? Other states that aren't Florida. It's persuasive, it's not binding. California Court of Appeal. It's binding in California trial courts. It's persuasive in Florida courts and vice versa. Y'all getting me? Y'all catching on? I'm gonna give y'all a real world example, okay? Let's say you're in Florida, but there's no Florida case on whether Venmo payments are considered as child support, all right? But California has a case saying that they don't count at all, okay? Your Florida judge is not bound by this California case, okay? He can look at it and say, that's a good reasoning. You know what? I'm gonna follow that case law that you got from in California that says Venmos should be used for child support because of this reason. I like that you brought that to court. I'm gonna use that and say your Venmo payments kind of child support. Do they have to do this? No, they don't have to. Okay, because guess what he could do? Ignore it entirely. He can just throw that out the window, but that ain't even in my state. I ain't gotta listen to that. I ain't gotta look at it. Get it out of here. I don't have to pay no mind to that California case law because I am in Florida. All right. Now, why the lower court's case matter? Okay. Now, I know you might be wondering if the higher courts create binding precedents, why cite lower case law at all? Why don't just go get all high case law, cite that in court? I'm gonna tell you why. The Supreme Court doesn't rule on everything. The U.S. Supreme Court, they only rule on certain things, okay? So the U.S. Supreme Courts take about 100 to 150 cases per year out of thousands and thousands of requests, okay? They focus on constitutional issues, conflicts between federal circuits, major questions of federal law. Okay, all right. They've ruled on maybe a handful of child support issues. I have been telling y'all this. You got Turner v. Rogers, and that's about your ability to pay. How you can't be locked up. You got to show that I can pay this purge before you just send me to jail. So that's a good one to know. All right. Turner v. Rogers. Then you got Blessing v. Freestone. That's a Title 4D. That's about I think it's about child support, specifically how the mothers wasn't getting their payments, and it was again, we're getting all right. So reason two of why the family court is mostly state law. All right. Child support, custody, visitation, divorce, these are all governed by primarily state law. Okay. That means state appellate courts make most of the relevant case law. So when you want to look at something for child support, look at the DCA, look at the appellate process. All right. Florida Supreme Court and Florida DCA are where Florida family law gets decided. Okay. So when something go wrong, you gotta appeal it. A lot of relief is brought to you in the appellate process. You're not gonna get, sometimes they don't follow the laws the right way in the lower court. The lower courts will get it wrong. You have to appeal it, you have to object certain things, you have to hold your rights intact to be able to appeal these situations. So that's the same for every state, all right? So persuasive authority fills these gaps, okay? So when there's no binding case in your state, judges are going to look at other states that have addressed the issue already, federal courts that have discussed similar concepts, and legal treaties and law review articles. So if something's already drawn up about this topic, they'll go to that. Let's say there's no topic over if it's supposed to be considered as property in a divorce, which I'm sure they are somewhere in there. Let's say there was no law like that in Florida. But in California, it says the person who walked the dog more times than not get to take the dog. Okay, they may look at that and utilize that. Y'all get what I'm saying? Okay, so gotta understand persuasive authority. It fills the gap. All right. So if there's something missing in your state, that's why they use lower court arguments to go ahead and fill in that gap, because the U.S. Supreme Court and federal courts only hear certain types of cases. All right. So a well-reasoned California case might persuade a Florida judge if Florida hasn't ruled on the issue. I just explained that. So we have to understand that there's building blocks to law. Higher courts rely on lower courts' reasoning. When an issue keeps coming up in trial courts and appellate courts, eventually a Supreme Court might take it up and make a final ruling. Lower court cases show how the law is developing. They're like the laboratory where legal arguments gets tested. All right. So we're gonna try to do a quick reference. So when you see the U.S., that's the Supreme Court. S.CT, that's the U.S. Supreme Court as well. Then you get into F.3, that's going to be the Court of Appeals. And then you go to appeals by states, New York, California. All right. All right. So that is the hierarchy. Okay. It goes Supreme Court. Everyone in the country must follow this. Federal circuit courts, lower federal courts in that circuit must follow this. State Supreme Court, all courts in that state must follow this. State appellate courts, trial courts in that state or district must follow this. Trial courts, generally no one has to like follow these rules. There's going to be precedents that make trial courts. All right. So I want to go over some common family law citations that you'll use, like Turner v. Rogers, and what it stands for. So courts must determine the ability to pay before jailing someone for contempt. All right. You got Santosky v. Kramer, 455 US dot 745 1982. And this is clear and convincing evidence needed to determine parental rights. Again, we'll get into that. Blessing versus Freestone. And I know y'all hear this a lot. So that's 520 US dot 39 1997. Title 4D enforcement is federal state system. All right. We get into that. And you got Hicks versus Viock. Feiock. And that's civil versus criminal contempt distinctions. You need to know the difference between what rules apply in each one. Then you got Troxell versus Grainsville, 530 US dot 57 2000. And that's parents have a fundamental right to direct children's upbringing. Okay. So we're going to try to get out of this, get back into the meat and topic of the podcast about knowing your rights. I wanted y'all to learn how to read case law, man. Y'all need to know how to read case law for sure to understand what's compelling and what runs your state, your situation. So we're going to get into the meat and bones of this. We'll probably cut some of this back through editing. I'm learning. This is our first podcast episode. I'm going to try to shorten it. I started doing wanting to try to get into this because I'm like, man, I can't get my point across in 30 seconds, but I definitely got to be able to do it within a matter of hours. So I wanted to break that down for y'all. I may take intermissions into this. It's going to be one episode, but like even now I'm getting a phone call. I'm going to answer this and we'll get back into it, y'all. All right, parents? All right, parents, let's get back into it. Excuse me. Got my kids calling me. Got my oldest daughter out in South Carolina. Anytime she call or text, I kind of got to just definitely check in with her to see what she got going on. I get hopefully my video editor get us back in the right spot. So we went over the hierarchy of the courts and the case laws and persuasive and binding, what's going to work in your state or your jurisdiction. So I want to try to touch back over those points to make sure we're all on one accord still. So we need to understand that family courts operate on different terms than criminal court, okay? Criminal court is going to be beyond a reasonable doubt. Family court, you're going to use a preponderance of evidence. That's that more likely than not. This means how you present your case matters just as much as what's true, okay? Because judges have a wide discretion. Your attitude is part of that, okay? That part of the equation and what they use. How you carry yourself in family court matters, maybe versus criminal court, not so much. So again, the whole reason we went over how the case law works and how you break it down, because that is what laws and everything is structured on. You need to know what cases determine what. So we're going to get into these into this point of how the family court operates under different standard. And the first case law we're going to go over that is going to be Santosky versus Kramer, 455 US 745 1982. So this is Supreme Court. Okay. So the holding was, before the state may sever parental rights, due process requires clear and conspicuous evidence, okay? No, clear and convincing evidence, excuse me. But this is still a lot lower than reasonable doubt, okay? So that's the standard is still lower, all right? So the key quote from that case was, the fundamental liberty, interest of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents. Just because you weren't the best parents, a model upstanding parent to the T, does not mean your rights just evaporate, okay? Why this matters, all right? Most custody disputes use preponderance, even lower than a clear and convincing amount. They just use the preponderance amount of evidence, okay? That's lower than what they need to be using. Lower than clear and convincing, okay? Parents need to only tip the scale slightly for them to lose, okay? Just keep that in mind. All right, I want to get into the background of this case. Again, this family court unfiltered. This might need to be family court education 101 because we want to get into this Santosky v. Kramer. All right, so the background of it was John and Annie Santosky, all right? John and Annie Santosky had 3 children removed from their, I think it's Ulster County DSS between 1973 and 1976, okay? The state moved to permanently terminate their parental rights based on allegations of neglect, all right? The background of it, or what actually happened, was New York law only required the state to prove neglect by a fair preponderance of evidence. Basically, 51%, okay, to permanently terminate parental rights. The Santoskis argued this standard was too low for something as serious as permanently destroying a family. I that. Lower New York courts upheld the termination, though. The case went to the Supreme Court. The legal question: What standard of proof does the Constitution require before a state can permanently terminate a parent's rights? Okay. Outcome. The Supreme Court ruled 5-4 that the Due Process Clause requires at least clear and convincing evidence before terminating parental rights, not just a preponderance. A little higher, not that much higher, but we'll take it. The termination was reversed and sent back for a new hearing under the higher standard. This is why holding certain things in court, holding things for your appeal, pushing it up and up can matter. They got all the way up to the Supreme Court and got their kids back. So this is the case that established parental rights are fundamental liberty interests. This was the case that did that. All right. Preponderance is 51%. It's fine for regular civil cases, but not for ending a parent-child relationship forever. All right. Clear and convincing is a middle ground between preponderance, which is 51%, and beyond reasonable doubt, which is more of a criminal situation that requires 95%. All right. So clear and convincing is higher than preponderance, a preponderance of evidence, but lower than a reasonable doubt. Y'all got that? Okay. Your rights can still be terminated. They just have to work a little harder to do it. All right, parents? So let's lock in. All right. So it came out of New York. The state tried to permanently take 3 kids using only a 51% proof standard. The Supreme Court said that when you're destroying a family forever, you need more than probably. All right. You're going to come with probably. That's why we have clear and convincing now. That was the case that created clear and convincing. All right. But that's still not beyond a reasonable doubt. It's still 2 different things. All right, family. We have to understand that family court, criminal court, 2 different standards, 2 different ways to use your rights. All right, parents. Okay, let's get moving. All right, let's get to actually let's stay in that. Let's get to another case law though. We gonna go with I think it's Trox L versus Grainville, 530 U.S. 57-2000, another U.S. Supreme Court. Okay, so listen, the holding was the interest of parents in care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. Okay. So, why does that matter? Even though parental rights are fundamental, courts retain broad discretion to determine best interests. Okay? Judges can override parents when they believe it serves the child, and attitude and presentation affects that judgment. Okay? So, how you carry yourself in court can, can determine how a judge rules in family court. Okay? So, let's try to get into the meat and bones of that case. Troxell versus Grainsville, 530 U.S. 57, 2000, U.S. Supreme Court. Okay, so let's get into the background. You had Tommy Grainsville and Brad Troxell. I'm not sure if I pronounced them right, but like I said, my video editor have them spelled the right way. So they had 2 daughters, but they were never married. After they separated, Brad lived with his grandparents and he brought the girls over for regular visits. But Brad committed suicide in 1993. The grandparents wanted to continue seeing the girls, okay? So what happened? The mother, Tammy, did not cut off the grandparents. What she did is she just allowed limited visits to 1 short visit per month. The grandparents sued under a Washington law that let any person petition for visitation if a judge thought it was in the child's best interest. The trial judge ordered more visitation than the mother wanted, basically overriding her parenting decision because he thought more grandparent time was better for the child, okay? I was just in a group arguing this. Now, I'm not saying this is going to uphold. We're going to keep getting into the meat and bones of it. But there are laws in states where, as a grandparent, you can petition for visitation rights. You can petition for rights, for visitation. You can. Now, if you win, that's going to be up to the judge's discretion. But let's get into it. So let's get into the legal question of it. All right. Can a judge override a fit parent's decision about visitation just because the judge personally thinks a different arrangement is better for the child? Can a judge do this? Okay, so the overall outcome is Troxell came out of Washington after her father's suicide. The grandparents wanted more visitation than the mother was offering. The Supreme Court said judges can't just override a fit parent because they think they know better, okay? But here is the catch. You have to be a fit parent, deemed fit by the courts, okay? That's the catch 22, okay? So that's Troxell v. Grainsville. Now we're going to try to get into remarriage of Lamonxa, 32 Cal. 1072, 2004. So that's coming out of the Supreme Court of California, where they held that courts must consider the totality of circumstances with emphasis on patterns of behavior over time rather than an isolated incident, okay? Why this matters, one bad day in court, one hostile CPS interaction becomes part of a documented pattern, okay? Judges look at the consistency across time. So let's get into that. The background of this case, a custody modification case where the custodial parent wanted to relocate out of state with the children. The other parent was opposed to the move. So let's see how they handle this. What happened? The California Supreme Court evaluated the case by looking at the moving party's long-term pattern behavior, history of facilitating the other parent's relationship, and overall parenting conduct, not just the circumstances of the move request itself. The court emphasized that custody decision must consider the totality of a parent's conduct over time. So what was the legal question? How should courts evaluate parenting fitness and best interest in relocation cases? When parents are about to move, relocate maybe into a different state, how should they handle it? By isolated incidents or by overall patterns? I think that's going to be an easy one to figure out how they determine that one. But the outcome, the court established the judge should evaluate a parent's demonstrated pattern of conduct, not isolated moments. A parent's long-term history of cooperation, stability, and child-focused decision-making weighs heavily in this analysis. So the judge looked at your pattern, who'd you been consistently over time, okay? One bad day doesn't sink you, but one good day doesn't save you either, all right? This is why documentation over months and years, it really does matter. I preach this a lot on my pages when I'm jumping out trying to get information. Documentation matters. It really does, okay? Your history of cooperating or not cooperating, okay, with the other parent will get considered. Courts want to see stability and consistency, not just promises, all right? How you've handled conflict in the past predicts how you'll handle it in the future. This is what the judges believe, all right? So, Lamonxa came out of California. It's a relocation case, but the real lesson is how judges evaluate you. They're looking at your pattern over time, not just today. If you cooperated, you've been cooperative, stable for years, that matters. If you've been fighting, hostile, getting into it for years, that's going to matter too, okay? So we're going to get into one more case law over this point, and then we'll try to get into the next factor, okay? So we got Lewis versus Lewis. That's 392 S.C. 38 2011. SC, that's going to be the South Carolina Supreme Court, okay? The holding was the highly fact-intensive nature of family court matters lends itself to a respect for the factual findings of our able and experienced family court judges who are in a superior position to assess the demeanor and credibility of a witness, okay? Therefore, the judge has strong credibility about how he witnesses you, how he sees your demeanor, how he gets to his credibility. Your witness's credibility is determined upon the judge, okay? Why that matters? Appellate courts almost never overturn credibility findings, all right? Once you damage your credibility with the trial judge, there is no reset button, all right? Witnesses, stay on point. So we're going to try to get into the meat and bones of this, the background of this case of Lewis versus Lewis, all right? A custody dispute that went through trial court and then was appealed, all right? The losing party challenged the trial judge's finding about the witness's credibility. He didn't agree with him, so he went to appeal it. What happened? The trial judge made determinations about which witnesses were credible and which weren't, based on watching them testify in person. On appeal, the losing party argued the judge got it wrong and misjudged the credibility of the key witnesses. The appellate court was asked to second guess the trial judge's impressions. So let's break it down. All right. So the legal question: should appellate courts overturn a trial judge's credibility determinations when reviewing family court cases? What was the outcome, y'all? Okay. The South Carolina Supreme Court reaffirmed that appellate courts give great deference to trial judges on credibility findings. The trial judge got to see the witness. He saw the witnesses, their demeanor, their body languages, their attitude, the way they responded, how they acted under pressure. Appellate courts only read cold transcripts. They're just going to read what happened in the lower courts. That's why transcripts are mandatory. And that's why certain things are a lot harder to get overturned. Because as you see here, unless the trial judge was clearly wrong, credibility finding stands. The appellate courts can't overturn something they can't see. All they can do is read it. We didn't get to see how the witnesses were in themselves, so we have to go with the trial judge's decision, okay? So, trial judge's impersonation of you is almost impossible to overturn on appeal. Appellate courts read transcripts. They didn't see you sweat, hesitate, or get angry or cry. They didn't see that. Your demeanor on the stand becomes part of the permanent record, all right? This is why how you represent yourself matters as much as what you say, if not more, okay? If you come across as hostile, evasive, or dishonest, that's going to stick with you, okay? Credibility findings are the hardest thing to challenge on appeal. So y'all carry yourself properly when y'all go to court, all right? Lewis came out of South Carolina. Someone tried to appeal saying the judge got the credibility clause wrong. The appeal court basically said, look, we weren't there. The trial judge watched the witnesses. We're not overturning that, okay? We can't overturn that. Your demeanor in front of the judge matters because it's almost impossible to undo, all right, y'all? That's touching the base in in point one. So we're going to try to keep it going. And we're going to try to get into the CPS, okay? These CPS situations, all right? So we need to understand that CPS is not law enforcement, all right? And that really thing in the situation, because you have to understand that there are two different rules, two different things they have to abide by, okay? So CPS workers are child welfare investigators. They're not cops. They simply write reports, and their reports are going to become evidence, okay? That's why how you answer that door, where you come to it, whatever, however this thing happens, it matters because the CPS report is going to become evidence, all right? Uncooperative in a report can hurt you for years. You talking about how I plead the fifth. I know my rights, get off my property, do all this. Okay, be uncooperative with these people and see how that can turn out, all right? You can decline certain things and remain cooperative. You can stand on your rights, you can. You can say yeah to everything they say, but it is about how you do it, all right? So the CPS is not law enforcement, and that really does change some things. So we're going to try to get into the meat and bones of this. All right, so the principle, CPS workers are civil welfare investigators. They are not the police, okay? Switch my screen around. Excuse me. Like I say, I'm new to this. I ain't true to this, y'all. I got a bunch of different screens up with information. I want y'all to get this information because y'all need it. Y'all need to understand how laws apply to y'all. So listen, principle, CPS workers are civil child welfare investigators. They are not the police. They don't need probable cause, okay? They write reports that become court evidence. Being labeled uncooperative will hurt you for years, all right? That is a key point that we have to make. Let's get into the case law with these CPS situations, all right? We got Wyman versus James, 400, U.S. 309, 1971, all right? So that's coming out of the U.S. Supreme Court, all right? So what was the holding? Home visits by child welfare workers are civil/administrative in nature, not criminal searches requiring traditional Fourth Amendment protections. Okay? All right. So why does this matter? This is why I don't consent to searches doesn't work the same way with CPS as it does with the police. Different legal framework entirely, parents. So let's try to get into the meat and bones of this case. Wyman versus James. Again, a U.S. Supreme case law. The background. Barbara James was a single mother receiving AFDC, which is welfare benefits in New York. A caseworker scheduled a home visit as part of the program's requirements. What happened? Okay. James refused to allow the caseworker into her home. claiming the visit was an unconstitutional search under the Fourth Amendment. She didn't claim that she didn't have anything to hide, all right? She argued on principles that the government couldn't condition benefits on giving up her Fourth Amendment rights. New York terminated her benefits, okay? She sued, arguing the home visit requirements was unconstitutional, okay? Legal question. Are CPS-style home visits considered searches under the Fourth Amendment that require warrants or probable cause? All right? Question mark. Outcome. The Supreme Court ruled 6-3 that home visits They ruled 3-6 that home visits were not a search in the traditional Fourth Amendment sense, okay? The visit was rehabilitative, not investigative, okay? It was scheduled in advance. The consequences of refusal was losing benefits, not criminal prosecution, okay? Therefore, Fourth Amendment protections against warrantless searches don't apply the same way in CPS cases, okay, or in family court at all for that matter. So we have to understand this, okay? We talking this unconstitutional nonsense. It's only gonna get you but so far. So let's try to take away some key points here. CPS workers are not the police. Legally, they operate under different rules. Home visits are considered rehabilitative, not investigative, okay? In legal terms, all right? The Fourth Amendment does not protect you the same way it would against cops. You can refuse a home visit, but there may be consequences like losing benefits or looking uncooperative, okay? This is why I don't consent to searches. Doesn't work the same way as people think, okay? It's not going to work the same in family court, all right? CPS rights report that become court evidence, all right? Police write arrest reports. They're two completely different things, all right? So, again, woman came out of New York in 1971. A mother refused a caseworker a home, claiming it was an illegal search. The Supreme Court said CPS visits aren't police searches. Different rules apply. That's why I do consent speech. It just works the same way as it does when cops pull you over or something like that, okay? So, let's try to get into another case law into the understanding of how CPS is not law enforcement, okay? Andrew versus Hickman County, 700F.3D845. That's going to be the Sixth Circuit Court in 2012. So the Sixth Circuit Court of Appeals, this was the holding. The Fourth Amendment standards do apply to social worker. There is no social worker exemption, okay? So let's get into the meat and bones. Why does this matter? Parents have constitutional rights, but the remedy is a civil lawsuit after the fact, all right? We ain't saying y'all can't sue, but that's not going to win your CPS case or your family case, okay? Just because you sue or try to sue, that ain't it, all right? There's no exclusionary rule in family court. Illegally obtained evidence still comes in. Your resource is separate litigation, not suppression. You can't suppress what you feel is wrongful evidence that come into the courtroom. Okay? Not in family court. We're gonna try to get into the meat and bone of this. And we probably do this every episode, but we'll see what I'll try to get some reviews on what y'all think, how deep dig into this case law. Like, because I want y'all to understand the merits. I don't want y'all just using case law because you think it's beneficial. You need to understand what went on, what were they arguing about, why were they there, where was it ruled, what state was it in, what court was it in, which jurisdiction. You need to understand these things to really become knowledgeable in this, okay? So, Andrew versus Hickman County, 700F.3D845, Circuit Court, okay. So, this is the Sixth Circuit Court of Appeals. The state origin is Tennessee, all right? So we're in Tennessee, and that's going to cover Tennessee, Kentucky, I think it's Ohio, Michigan, I think as well. But anyway, okay, so the background. A family in Hickman County, Tennessee had abuse referral called in. CPS reported to investigate. What happened? Okay, this is what happened. Social workers arrived at the home and removed the child without first obtaining a warrant or emergency court order. They claimed extrinsic circumstances. After the investigation concluded and the family was cleared, the parents filed a federal civil rights lawsuit under 42 U.S. 1983. These are the claims that you're going to have to file under for your rights, okay? Against the county and the individual social worker, claiming their Fourth and 14th Amendment rights were violated. What is the legal question, all right? Can social workers be sued personally for money damages when they remove children without proper legal authority? Okay, the outcome. The Sixth Circuit Court held that social workers can be held personally liable under Section 1983 for constitutional violations, all right? However, they may have qualified immunity if they reasonably believe their actions were lawful. The key point, this was a civil lawsuit after everything happened. It didn't help the family during the actual removal, okay? It did nothing for them while the case was going. I need y'all to understand that, okay? So, yes, you can sue CPS workers later if they violate your rights. This is a separate federal lawsuit. It doesn't happen in family court, okay, family? Okay, parents? Okay, listeners? All right? It doesn't stop the removal while it's happening. It's an after the fact remedy. Qualified immunity protects workers who reasonably believe they were acting lawfully. Even if you win the lawsuit, it doesn't automatically get your kids back. This is why knowing your rights isn't enough. You need strategy for that actual moment, okay? Now let's run it back again. Andrews came out of Tennessee. CPS took the kids without a warrant, and the parents sued later in federal court. They won, but here's what people miss. The lawsuit did not help them during the removal. By the time you file a federal lawsuit, right, case, the damage is already done. You need strategy for the moment, people, okay? All right? Not just knowledge for a lawsuit later. No, that could take a year, 2, 3, 4, 5. You want to be waiting that long? Like, come on, y'all. Okay. All right, so let's get into it. I got some more case law, but I ain't gonna keep digging into that. I got a Dupe versus Samuels, 465 F.3D757. That's the Seventh Circuit Court in 2006. The holding was CPS investigations are administrative process where non-cooperation can legally be used against parents in subsequent proceedings. Y'all understand that? So why this matters? Direct authority that your refusal to cooperate becomes evidence against you, okay? All right? CPS doesn't need to charge you, they just need to document your behavior for it to become evidence in the court or in family court, okay? So then you got Nicholas versus Scopetta 344 F.3D 154. That's the Second Circuit Court of 2003. Holding the agency must balance investigation powers with due process protections, but parents must engage strategically rather than defensively. I'll be telling you this all the time. Take them notes out the window, talking about we ain't letting you come in. Say that for ISIS, okay? Not for CPS. All right, so what does that mean? Establishes that is a balance. Parents have rights and responsibilities. Strategic engagement beats blanket refusal. Stop just refusing people. Stop just refusing saying you can't come into my home, all right? So we're almost to there. We're gonna try to get point 3 across, and I'm gonna take a break and come back to it. The game finna come on. I know I'm a FSU baby, but I'm rooting for Florida. Let's go Miami. But let's try to get this through before the game come on. Lock y'all in. Let's lock in, all right? So let's try to get to point 3. Why I don't consent and plead the fifth can backfire, all right? Let's get into it, okay? I'm going to try to touch a few bases, okay? Because these phrases, they work in criminal stops, not in child welfare cases, okay? The Fifth Amendment protects against self-incrimination in criminal cases. Family court can draw negative inferences from silence. They can draw negative thoughts from silence. They can assume that when you refuse to talk, it's because it's something bad you don't want to say. They have a right to do that, and y'all need to understand that, all right? Judges interpret refusal as, what are you hiding? Like I just said, man. So listen, let's get into this. Let's get into the principles of why I plead the fifth can backfire in family court. Again, the key principle, the Fifth Amendment protects against self-incrimination in criminal proceedings. In civil proceedings, including family court, and courts can draw adverse interference from silence. Silence make judges suspicious. Okay, parents, we go get into the case law behind of how case law supports this argument, all right? So let's get into it. Let's get into it, parents. I like to show and prove what I'm telling y'all. We're going to get into is going to be Baxter versus, I think it's Palmeganio. I'm not sure. Don't worry, it'll be spelled right on the screen, okay? So this is going to be 425 US 308 1976. And remember what I said, y'all, when y'all see the US, that's the big dogs. That's the top supreme. And don't get no higher than that. They are the bosses, all right? So listen. The holdings of this case was the Fifth Amendment does not forbid adverse inferences against parties to civil actions when they refuse to testify in response to probative evidence offered against them, okay? So why does this matter, all right? This is the case that parents really need to understand, all right? This is one of the main ones because you can invoke your fifth in civil proceedings, but judge, they can assume your silence means the answer will hurt you, okay? That's the complete opposite of criminal court. So watch where y'all get y'all information. Come on, man. We go dig into this Baxter case. And again, it's the U.S. Supreme Court. So let's get into the background of it. We're going to call it P because I don't know how to pronounce this person's last name. I don't want to keep butchering it. Again, it'll be on the screen. Nicholas P. was an inmate at Rhode Island Adult Correctional Institution. He was charged with inciting a disturbance during a prison riot, okay? Facing both prison disciplinary charges and potential criminal prosecution. So what happened, all right? At his prison disciplinary hearing, this is a civil proceeding. This is considered a civil proceeding, okay? Nicholas was advised he could remain silent, but was also told his silence could be used against him in the disciplinary hearing, okay? In the decision that they made. His silence can be used against him. He stayed silent. The disciplinary board considered his silence as part of their decision against him. He argued this violated his Fifth Amendment rights, which gave him the right to remain silent. So let's get into the legal question of it, okay? In a civil proceeding, which understand, family court is a civil proceeding, all right? So in a civil proceeding, can a tribunal draw negative inferences from a party's decision to remain silent? Tribunal is just like who's ever over it, the judge, the hearing officer, whatever. The outcome of this was the Supreme Court ruled that the Fifth Amendment does not prohibit drawing adverse inferences from silence in civil proceedings, okay? This is unlike criminal trials, okay? Where silence cannot be held against you. In court, silence cannot, your Fifth Amendment, you can invoke that. Silence cannot be held against you in the court of law, in a criminal court of law, okay? All right, y'all. I need y'all to understand that. So, unlike criminal trials where silence cannot be held against you, civil tribunals, including family court, can consider your refusal to answer as evidence against you. All right, parents? So, again, this is the case that kills that I plead the fifth in court, in family court, okay? This is the case that lets you know pleading the fifth in family court can hurt you, all right? Criminal court, silence cannot be used against you, but in civil court, it can. You need y'all to understand this. Family court is a civil proceeding. Baxter applies, not Griffin, okay? When you refuse to answer in family court, the judge can think, what are you hiding? Why don't you want to answer this question? What does answering this question do for your case? It must hurt you because if it helped you, you would answer it. And they're allowed to do that in a civil proceeding, okay? Your silence in custody case can be interpreted as evidence of guilt or wrongdoing. Okay, so Baxter, all right, is the case that kills I plead the fifth in family court, all right? It came out of Rhode Island, prison disciplinary case. The Supreme Court said in civil proceedings, your silence can be used against you. Family court is civil. When you refuse to answer, the judge doesn't think that you're exercising your right. He thinks that you are hiding something. What are you hiding? Okay? So, it'll backfire. Now, we're going to get into some more case law. And again, as time moves forward, hopefully I won't have to read. I probably won't read through all of the case law that I'm pulling up and studying to give to you guys. A lot of that may end up just being on my pages or information in general. I'm gonna try to push this information out as much as I can. I really feel like we need it, parents. Like, we're out here invoking the wrong rights the wrong way, and I think we really need to get an understanding of that. So let's go to the next case law. That's gonna be Griffin versus California, 380 U.S. 609, 1965, okay? U.S. Supreme Court. So, and you'll see these dates that go further back. It's just because they they've been going and adjusting laws for years and years and years. If something higher comes up, then it'll replace it. But when you see these standings, they still stand because this is the original case law that was created that talked about that issue at hand. So that's all it is. It's a top dog. It's not that, oh, because it's from 1965, it's unusable. I can't use it here in 2025. No, that's not the situation. They tackled this issue back in 1965 or 1980 or 1917 or 2017, whatever the case number is just them arguing that topic in that year. So this was decided in 1965. So when you see that, it's like, bro, these laws been around for years and years. These constitutional arguments, they have been around for years. And my thing is, if you cannot find it in a case law, you can't find nobody that actually won off this. I'm talking one or two people ain't it. Find an actual foundation that you can build your case on and work from there. Because everybody's situation is going to be different. The merits are going to be different on everybody's cases. So y'all are buying these template, boilerplate answers and think because it worked for this person, it's going to work for you, when that's just not the case. So let's get into it. Griffin versus California, 380 U.S. 609, 1965. The holding was, in criminal cases, the Fifth Amendment forbids either comment by the prosecution on the accused's silence or instructions by the court that such silence is evidence of guilt. So that's pretty much saying, listen, in criminal cases, when you're quiet, you cannot you cannot speak to the jury or speak to the fact that his silence should be used against him. And we'll get into that. So why does this matter? This is what parents think applies to their family court situation, but it does not, okay? Griffin's protections are for criminal proceedings only. Baxter explicitly distinguished civil context. So that's the difference. The case law we just seen, Baxter, that was breaking down why or how the fact that you being quiet or I plead the fifth in a civil proceeding does not align the same way like in Griffin's case, which is a criminal proceeding. So we're going to get into the background of Griffin because y'all know I like to dig deep. So listen, Eddie Dean Griffin was charged with first-degree murder in California, okay? At his criminal trials, he chose not to testify on his own defense. He didn't want to testify. He chose to remain silent. He exercised his Fifth Amendment right to remain silent. So what happened? The prosecutor commented directly on Griffin's silence during his closing arguments, essentially telling the jury if he were innocent, he would have came up here and spoke. He would have spoke to his innocent instead of remaining silent, okay? The jury convicted Griffin and he was sentenced to death. Griffin appealed, arguing the prosecutor's comments on his silence violated his Fifth Amendment. What happened, y'all? Or better yet, what is the legal question? Excuse me. In a criminal trial, can the prosecution comment on the defendant's decision to testify or not to testify? All right. What was the outcome? The Supreme Court reversed the conviction, holding that the Fifth Amendment forbids prosecutors from commenting on a defendant's silence in a criminal case. All right. The court said allowing such comments would make the right to remain silent meaningless. All right. It would penalize defendants for exercising a constitutional right. See, that's what y'all are thinking applies to y'all in family court or when the CPS shows up. Parents, family, it does not. They are two completely different things, and we need to understand this. All right. So this is the case that people wrongfully apply to family court. Okay, they're thinking this case applies in their family situation or in civil proceedings. It does not. All right. Griffin only applies to criminal prosecutions. In criminal court, prosecutors cannot mention your silence, period. They can't say anything about your right to remain silent. They can't bring it up whatsoever. All right? So, but family court is not criminal court. Griffin protection doesn't transfer to court. All right? It doesn't transfer from the criminal stage to family court. It only applies in criminal proceedings. Y'all have to understand these case laws don't apply to everything. All right? People learn about the Fifth Amendment from crime shows and then misapply it. Y'all go be listening to that TV show. I plead the fifth. I refuse to talk, all of that. And y'all think it's going to apply to every situation. Family. Come on, I was lost too, but I'm trying to wake y'all up. So compare Griffin, criminal, to Baxter, which is civil. Opposite outcome on the exact same situation to remain silent. Y'all got to understand these case laws, man. So listen. Griffin, this is the case that people think that is going to protect them everywhere. It came out of California. It's a murder trial. The Supreme Court said prosecutors cannot comment on your silence in a criminal case, okay? But here's what people miss. The criminal court and family court are two different things, all right? They really are. Family court is civil. I can't say that enough to people. Griffin doesn't apply. Baxter does. And Baxter says your silence can absolutely be used against you in family proceedings. Need y'all to understand that, all right? Y'all got me? So let's get into another case law on this topic and we'll try to move to point four. Better yet, I'm going to just give y'all the case law. It's in Read AM 139 P.3D 915. It's an Oklahoma abbreviation in 2006. So this was an Oklahoma Supreme Court. The holding was dependency courts may consider a parent's refusal to cooperate when evaluating child safety and best interests. So when y'all are not cooperating, and trust, listen, family, we go get into how to cooperate the right way. I don't want y'all to think y'all ain't got no rights and we just ain't go touch base on how you properly handle these people or deal with these people. We're going to get into that. But I need y'all to understand what y'all have been doing wrong. Because like I said in the beginning, the goal is to teach y'all how to do it right, but I need y'all to understand what's killing y'all in court, what's murdering y'all in these situations, to the point where good family are getting kids taken from them by technicalities. Something may have happened, something may have went wrong, CPS is involved, GAL is involved, and y'all don't know how to move, even though y'all may be great parents. Anything can happen, an accident can happen, somebody falsely reports you. A lot of scenarios can put you in front of these people, even though you are a great parent. So you got to know the technicalities of it. You got to know how to protect your children, how to protect yourself, and not how to hurt yourself as well. Because a lot of y'all are hurting yourself. So try to get y'all right. We're going to try to stay focused. Again, in this case, why did that matter? The state court authority confirming that non-cooperation is a factor in the best interest analysis. Judge asked, if nothing's wrong, why won't you just explain it? And they're allowed to do this in family court. This is not criminal court, different proceeding. Give y'all one more case law. We're going to try to jump on to point four. So we can get y'all how to move the right way. Telling y'all how not to move. I'm telling y'all the case laws y'all been hearing going viral, thinking this Turner v. Rogers, how you sue. Listen, we gonna get into all of that. Maybe not on this episode, but y'all stick with me. I'm gonna put y'all in the right driver's seat to be able to take over your situation. Stop depending on somebody to write you a template, something that don't even apply to your situation. I think it's, what I am gonna do, I'm gonna take these names and go put them in the dictionary and see how to, people got some crazy names, man. No offense. Again, the words will be on the screen. I think it's El Dihadin versus El Dihadin. 26 NY 3D 19 to 2015. So this is the New York Court of Appeals. And the holding, a negative inference may be drawn in the civil context when a party invokes the right against self-incrimination. Okay. Here, defendant can invoke the privilege, but that did not relieve him from his burden to present adequate evidence. Why does this matter? Even after invoking the fifth, you still have to meet your evidentiary burden. Silence doesn't make your obligations disappear. It just removes your ability to explain. Okay, family? So we got to understand what rights we are invoking and how to invoke them. Because we utilize them the wrong way, or we're just saying things in the wrong context. And the judge has already got us labeled as, oh, he don't know what he's talking about. He don't know what he's doing. He done found this on the internet. We finna have a field day with him. It don't matter. Y'all stay woke. So listen. All right, Pans, let's get into point four. I'm not going to keep telling y'all what y'all can't do and break down what y'all shouldn't be doing and not tell y'all how to move or what controlled cooperation actually looks like, okay? So just be calm. Be respectful with these people. You answer what needs to be answered, okay? And you can ask clarifying questions without being hostile. You can ask these people what's going on. You don't have to sound like you're an aggressive, mean person or anything like that. You can also decline home entry and offer other alternatives of speaking or getting some type of clearance. You do not have to let these people in your home, okay? And you can ask for things in writings. Like I need I need this to be clarified in some form of writing. You can do that without sounding like you're some paranoid, crazy person or hostile person. There's nothing wrong with getting things in writing. That's one of my biggest things. I'm a can you show me this in writing type of guy. Okay. So the goal is to not give them anything to write against you. You don't want them writing up in the record, I was hostile, you was refusing the entry, you wasn't cooperative, you was uncooperative. That is the goal, okay? To work with these people without sounding like you're dangerous of some sort, okay? So let's get into the breakdown of it, all right? So again, courts distinguish between boundaries and just outright refusal. Family, you got boundaries. Like, you do not have to let them people in your house. There are some forms of where this is crossing the line, and you should know how to stand on that, okay? So, how you assert your boundaries matter way more than whether you assert them at all. They care about how you're going about invoking your rights versus if you're doing it at all, okay? So, you can say no without acting like you're hiding something. There's nothing wrong with saying no, not letting them people in your house. So, there's nothing wrong with that, parents. I don't want y'all to feel like y'all have no defense against these people because you do. But let's get into the case law that supports these arguments, all right? Because again, y'all, the case law is the foundation. This is what laws are made on. They matter. And y'all got to understand what's going on and how to assert your rights and how to move in different proceedings, okay? So let's get into it. And I probably, the names that I can't pronounce, now that I think about it, because you got to excuse me. I'm new to this. I'm not true to this just yet. I am trying to form a podcast, but you may have parents driving and listening to this on the way to work, and they may want to play it back. They may not have the visual to see the cases get spelled out correctly on the screen, which my video editor would definitely do for the ones that's watching this on whatever platform I release my podcast on. But we'll start spelling out the names that I can't properly pronounce for the people that may be driving and listening. So, all right. So again, let's get to the case law of what controlled cooperation needs to look like for you and what's going to support that. All right. So in RE Christopher B. 823 NYS. 2D 433. This is a 2006 case. All right. New York Appellate Division. Excuse me. All right, the holding was court favor parents who demonstrate measured cooperation and good faith engagement, all right? Even when declining certain requests. There was nothing wrong with declining certain requests, all right? Why does that matter? You do not have to say yes to everything, all right? But the way you decline matters. Calm, reasoned response that offer alternatives get treated differently than hostile refusal. No, you can't come into my house. No, you can't see my kids. Don't worry about if we got food in here. We grown. My land, it's my property. Get my property. Ain't answering nothing. I'm invoking my rights. Read this little red sign that I got on my door that is really for ISIS and not even relative to my situation. That's what a lot of y'all be doing, man. Instead of understanding how to move with these people. Like, all right, I'm trying to get you out of the game. All right. So let's get into the meat and bones of the Christopher B. 823 NYS 2D433 2006 court. New York Appellate Division. The state is in New York. All right. So let's get to it. The background. A CPS investigation where the parent was facing allegation and pressure to comply with various agents' demands. All right, family. So that's the outcomes of them. Okay. So just remember, CPS, you can say no to them. All right. It's about how you say no to them. Okay, family. Offering alternatives is a show of good faith. I can't do that, but listen, I'm willing to do this. Okay. So fighting everything is going to make you look like you have something to hide. All right. But agreeing to everything, you can also end up that can backfire as well because you can end up waiving rights that you really should have kept. Okay? So the goal, don't give them anything negative to write in your report. Avoid that at all costs. All right? So tone matters just as much as substance. Hostile refusal versus calm boundary settings. All right? I'm trying to punch this into y'all head. We're trying to go over this. I want y'all to understand how you're supposed to be moving with these people, okay? So, all right, in this case, Christopher B., he showed controlled cooperation in the action. The parent didn't fight everything. They didn't agree to everything either, all right? They cooperated where it made sense and politely declined when it did not. All right. They also offered alternatives to what they felt like didn't work for them. Okay. So the court saw that as reasonable. That's the model. This is showing y'all how to work. Stay calm, be respectful, and don't give them anything to write against you. That's the goal, family. All right. That's what we're trying to. That's what we're trying to do. So one more time. Control cooperation. I'm going to give y'all a breakdown of before we get into these case laws, because before we get into more case laws, I may give y'all what? Let me see here. I may give y'all one or two more case laws on this, on how we maneuvering. All right, but because I want to drive these points home. So better yet, I'm gonna just give y'all the case law, and then we gonna drive these points home. We ain't go get into the meat and bones of every case. All right, I'm gonna grab one more case law for y'all on this, but first I'm gonna give y'all some like examples of controlled cooperation. All right, I'm gonna give y'all 5 examples to be exact. All right, what gets you in trouble versus what is keeping the terms of, okay, this is controlled cooperation. And that's what we need, y'all. We need to look cooperative with these people, but in a controlled way. I'm not telling y'all to give up all y'all rights. But example number 1, instead of just saying, I do not consent, you're violating my Fourth Amendment rights. All right? Instead of saying that, we go try to do this at the more calm way, all right? I'm not comfortable with the home visit today. How about, or better yet, can we schedule something at your office instead? Just calm, collected. Not comfortable with a home visit today. Can we just schedule something at your office instead? Example 2. Instead of just saying, I plead the fifth. I'm not answering any questions whatsoever. I'm pleading the fifth. All right, I'm holding my Fifth Amendment right. All right. How about we say this calmly? I prefer to have an attorney present before discussing any details. I'm happy to schedule a time. All right. Example 3. All right. Instead of you just saying this, okay? Instead of just saying, listen, you're not coming into my house without a warrant. You don't have a warrant, you're not coming into my house, period. Instead of that, how about we calm, cool, and collected always? I like to cooperate, but I prefer to meet at a neutral location. Would that work with you? So example number 4, all right? Instead of just saying, listen, I don't show you anything at all. How about this? I can provide documentations. Would you like me to email it, or should I bring it to your office? All right, we can show proof. We don't mind showing proof, but I do it the proper way, okay? And instead of just saying, listen, I know my rights. This is harassment. Y'all can't harass me like this. I know my rights. How about instead of that, I want to work with you on this, okay? But can you could you put in a specific request in writing so I can respond to that properly? All right? You don't have to answer any questions you feel uncomfortable with answering at that time. You just gotta know how to move the right way, okay? So let's get into the statute here. This is actually one of the statutes that helped me win equal custody of my child, all right? So I'm bringing out of Florida. That's gonna be a Florida statute 61.13 in quotations, in parentheses, the number 3. And this is the best interest factor. And like I said, I use this. And they have this, states tend to mirror in family court, okay? A lot of them mirror. So the best interest factors in Florida is a list of best interest for the child, what you need to go off of, what they are utilizing to tell you what they feel like is the best interest of your child. So you need to know them as well. And trust me, they probably have them in every state. I don't think there's a state that doesn't have a form of this in their state. Okay, so that'll be Florida Statute 61.13.3, best interest factors. Okay, so this is just the statutory authority in Florida. Factor A, the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, honor the time change schedule, and to be reasonable when changes are required. Okay? They're not expecting the baby moms or somebody to say no just because you're 30 minutes late, because you're 20 minutes late, or because you're running behind, or because a schedule needs to be adjusted. That, as long as you let them know in a reasonable amount of time, listen, things happen. So they're expecting parents to act like this. Oh, this is in the statute, okay? So then you also have factor J, the capacity and disposition of each parent to communicate and keep the other parent informed. The willingness of each parent to adopt a unified front. They want you working together. Hey, this is what's going on with my son today in school. He had this going on with the teacher. Can you assist him in this. This is what's going on in his doctor's appointment. I'm telling you, this is how it works. So why this matter? The statute explicitly rewards cooperative behavior. Similar provisions exist in virtually every single state, okay? Being difficult, even if you're technically right, can cost you these factors, all right? Right. And again, I'm not here to speak ill on any of the mothers of my child. I appreciate all the mothers of my children. I love my babies. I got a great relationship with all my kids, and I work very hard to do so. But I will say, adults don't always tend to agree. No situation is perfect, especially when you separated and y'all are expected to co-parent and do this reasonably. So that's why certain things are, and thank God for Florida, because like I say, in Florida, the situation with custody, it starts here. You both are presumed to be just as equal to each other. It's not a mother state, it's not a father state. But these things can be held against you when you go to court and you're one of the uncooperative mothers. You're one of the ones who argue everything, who don't let the child come over. You're liable to lose whatever it is that you're arguing for. Father, you can go 50-50, more time, primary, custodial. Y'all just got to know how to move in court and what rules apply to your situation. Not every situation is going to apply. So we went over the different phrases to say to sound cooperative, and we're gonna touch base on this last point. Okay, what actually protects parents? All right. So we're gonna get into point 5. This will be the last factor into the podcast 1 of the Family Court Unfiltered, episode 1. Why I know my rights can backfire in court, parents. All right. I've seen it too many times. I've seen so many videos go viral telling y'all what to say in court. And I work with some of these parents, and they've already on file as sovereign citizens, as a fictitious litigant, and we got to pull our way out of that. I heard up in a client now in California, and the judge, even though he originally filed some stuff, some stuff in that I know he got off the internet. Okay, we were able to still reel that back in, do some things properly, and we got, man, I'm hoping for some great victory story. We got some great testimonials coming up, man. I'm telling you, my clients, my students, because I don't want any confusion. I am not a lawyer. I am not an attorney. I am an educational consultant when it comes to family court and court situations in general, some civil, some other. Okay, I've been through the ringer, so I understand what's going on. I understand what works. I understand what's not going to work. I've tried that special appearance jurisdiction, and I'm telling you, if you don't know what you're doing, y'all crashing. You're setting yourself up for failure. You're setting yourself up for failure. I am telling you, I say 10 plus years of this, but in all actuality, I got an 18-year-old, and two 12-year-olds, okay? And a lot of these guys who I see talk about this, go viral, go do this, I'm gonna be honest with y'all. I don't see that. I'm gonna say it like this. The mothers of my children will come into court. On top of me going through with the state, on top of me, and this ain't no situation where the kids weren't mine and I'm able to get off due to fraud on the court. I stopped my ongoing support from studying and education and understanding, my rights as a father, getting equal custody, getting timeshare, understanding how my child support should have been adjusted and modified. And yes, I do have an avenue where I hopefully will be able to completely void out a child support order because the facts align in my situation for that one case. Now, the other two, that's different circumstances. I have to go get relief through a different avenue. Not every single child support case can be terminated. And if they telling you that, bro, they capping. They're lying to you. They're taking y'all money and they capping. Now, I go up, we can debate and talk. We can go law for law statute. I'm pulling up Google them. Google these statutes. I'm telling you, Google these case laws that we're going over. Go look them up. Stop reading cases for what you want them to see. Start reading them for what they really say. Go see what they were talking about that day. Go see what the argument was. What was the decision? What was the actual issue that brought it to whatever form of court, whether if it was the appellate, the U.S. Supreme? Y'all have to go look at the whole case entirely. Stop going off TikTok, Instagram, and all of that and thinking that that is the answer. They're not answering your questions. And I'm not here to say, yes, people have terminated child support. I've stopped all my ongoing child support. Yes, people have cleared out arrears. Yes, I got somebody, I'm telling you, I got multiple clients that are finna void out orders but the situation is different. It's different how they did it. It's completely different. And it's easier to catch it early on than 10, 20 years later. I'm not saying 10, 20 years later ain't possible because I know it's possible. I know for a fact you can get off child support 25, 30, 50, 100 years later. You can. Yes, you can. But there's a small avenue of people that can honestly do that. I believe every situation can, I'm getting off track because we're not talking about child support in this, not overall. We got plenty of episodes to get onto that. And trust me, we will. I hope that y'all stay with me, grow with me. This is my first time ever doing something like this in the form of just consistently recording and trying to push out information. This ain't even my forte. I got my own subconscious issues with being in front of cameras. I know I'm not, perfect by a long shot, but I feel like the message is bigger than me trying to sound perfect. You know what I mean? Because I know what I'm talking about and I've lived it. That's why that's why I'm confident enough to get out here to the internet where this could be seen by thousands of whoever may end up. I hope it reaches or is heard by the people that need to hear it. But I'm comfortable putting myself out there because I've lived this situation. I've helped parents. Man, when I think about some of my parents that came to me that had no knowledge of or understanding of how to move forward in their situation and where they are now, my palms, my hands start sweating sometimes. I'm like, bro, I done figured out a way that I can really help people and reach out to these people and they're getting the relief that I felt. Telling me they've learned so much and I know that feeling. I know that feeling from going from ignorant to just knowledge. And I'm like, man, it's not as hard as we think. And I'm not exempt. I go through battles right now. I'm trying to get my arrears cleared now. My baby, the mothers of my children, they is about that life. And I mean that respectfully. I mean that respectfully as possible. I say that because there's a lot of parents out here who are helping or trying to push information, ain't even got kids, ain't been in that situation where you really battling the court system or the mother, trying to get equal custody, trying to terminate child support, trying to have your rights upheld in court. You know what I mean? A lot of them ain't been through that. I've been through that 3 times over. I'm telling y'all what work and what don't work. Case law matter. All that internet bullshit does not work. It don't work. Yeah, it works for some people because it fixed their fat pattern. Some people, yes, y'all can, but bro, let me digress. Let me get back on to point 5, man. Let's get into this. We're going to get into point 5. What actually protects parents, okay? Let's talk about this, all right, family? So what actually protects parents in family court is going to be documentation, all right? You need your own record of events. You got to keep what happened, all of the interactions, everything. And then you got to be consistent. Consistency is really going to help you, okay? Same story every time you tell the story, it's the same to everyone, the judge, the CPS workers, everybody. Then you got stability, showing that you can provide a safe environment for your kids, all right? You got to show that in some way. I'm not saying you always got to let them into your home, but you got to prove that you are a stable and good parent. That's just what come with it when these situations occur, okay? Then you got credibility, and that's going to be how the judge perceives you, okay? How does he perceive your matter, your situation? What is he, and I hate to say it, that matters in family court, in civil matters. The judge has a say-so in your credibility and how he's taking in your word, okay? So strategic engagement, knowing when to push and when to comply. Again, I'm not telling y'all to just answer every question, do everything they're telling you to do. No, that's not the situation, but you have to have some type of control complying with these people, all right? So let's get into the facts, all right? Let's get into the points, all right? So the key principle here, all right? Judges do not reward who knows the most rights, all right? It don't matter if you know your first amendment, your second, third, fourth, fifth, and all of them, all right? That's not what they reward. They reward who looks the safest, the most stable, who's the most believable. That's what the judge is going to go off of. Knowing your rights is not going to be the answer. And then it's going to be documentation. Again, like I say, documentation, consistency, stability, and credibility is going to beat those constitutional slogans every single time in family court, okay? Every time. All right, so we're going to get into the case law that supports this, all right? Y'all already know how we moving by now. Okay, family. All right, let's get into the actual case law that is going to support what actually protects parents. So that's going to be Lear versus Robertson, 463 US 248. That's in 1983, y'all. So let's get it in. The U.S. Supreme Court held parental rights are protected when parents actively demonstrate responsibility. Okay, biology alone is not enough. Okay, being a sperm donor is not enough. The mere existence of a biological link does not merit equivalent constitutional protection. So why does that matter? Rights come from demonstrated action, not just assertion. Parents who show responsibility through documented behavior have stronger positions than those who just merely claim rights, okay? Right? I gotta understand that just saying I got rights is not enough. So y'all know what the next step is. Let's get into the meat and bones of this actual case. We not just go read the case, the title of the case, and not get into what took place, okay? So, Lear versus Robertson, 463 U.S. 1983. We out of New York, U.S. Supreme Court, okay? Jonathan Lear was the biological father of a child named Jessica, okay? He knew about the child but had never established legal relationship, never provided financial support, and never developed a parental relationship with this child, okay? What happened? The mother married another man, and the new husband wanted to adopt Jessica. They moved forward with the adoption without notifying Lear because he wasn't on any state registry and hadn't established fraternity. Lear filed to block the adoption, claiming his rights as the biological father were being violated, and he should have been notified to be given a chance to object to this adoption. Okay? What was the legal question? Does biological fatherhood alone, without demonstrated parenting responsibility, create full constitutional parental rights? The outcome? Supreme Court ruled against Lear. Biology alone is not enough. A biological father must take concrete steps to establish a relationship and assume responsibility for the child. Lear knew about Jessica for over 2 years and did nothing. The court said parental rights come from commitment and responsibility, not just DNA. That's a tough one, you hear me? The child 2 years old. Boy, you got lit. All right, fathers. Y'all using that excuse because she ain't let me around them. She won't let me. What efforts have you taken? What effort have you taken? I can't feel bad for y'all when y'all telling me the baby mamas ain't letting y'all do this. She ain't letting me do that. What have you done to do something about it? 2 years. I'm sorry. That I know I'm reading the case law and I go over them, but it's so much you gotta understand. I'm in Florida. I help a lot of different parents in different states. So I come across different situations and different case laws, studying their situation because every situation is different. Every state is different. I need y'all to understand that. Stop buying these boilerplate templates that have nothing to do with your situation, okay? But let me touch on this because this is crazy to me. I'm gonna be honest with y'all. Like, because I was young when I had children, 17, 18. I was young, okay? Well, younger, I guess. And man, as a father, as a committed father here today, and I would give my leg, heart, eyeball, whatever for my kids, and I mean that to the fullest extent. I wasn't like that in the beginning. It took me a minute to understand what fatherhood mean, what it meant to be a father, what it meant to have responsibilities and show up for your child. It took me a minute. And my goodness, it didn't take, it took well over 2 years. I'm gonna be honest with you. Don't get me wrong. I was there, birthdays, I'm always in my children's life if I wasn't going through something where I was incarcerated or something like that. But other than that, I've always been in my children's life. But man, just not the way I felt like I should as a parent when I look back on it. Now my 11-year-olds, my 12-year-olds that I got, they don't know another version that daddy's not around. My oldest, there was a point in time where it was an in and out fluctuation. So that's just it's scary to me. Boy, 2 years old, she don't even know what a daddy mean. I digress because I don't mean that. Because my 2-year-old, oh my God. Well, she's 4 now, but her at 2, whew, daddy not being around, that ain't it. All she know is daddy. So at 2, yes, they know daddy, but it's like, come on, that's really early. That's not giving a man a chance to Situations. That's why you got to be on top of this. And I'm not trying to make excuse for any father that's not in his child life. None whatsoever. Seeing my son get born, I almost fainted. Literally had to go sit me. I was one of them. I got all wobbly leg, my knees got shaky. I almost went down. But like I wasn't understanding of that in the beginning, early on, from having kids. You know what I mean? So 2 years, they ain't get this man 24 months. And his child was a gown out of there. You ain't a daddy no more. It's crazy work. So I'm sorry, I got stuck on that one. That one threw me for a loop. I remember this case, but reading it again just brought back like, dang, bro, your baby ain't nothing but 2, and she gone. I can understand. I feel like I could understand it more if it was like 5, 6, 7. 2, she could learn who another daddy is. No, I mean 2. Oh man. So let's get to the key points of this. All right. Biology does not automatically give you equal parenting rights. Okay, case law just showed it. You being the biological dad that ain't giving you no rights, and it's still like that here in a bunch of different states like Georgia, I think North Carolina. Boy, don't go foul that motion to have your parental rights. You know what I mean? Invoke. I think one of them is called like legitimization in Georgia, and then it's either North Carolina, South Carolina. You find like it's almost like a lawsuit. It's like a petition to something to get your. I mean, with a lot of different states, y'all. Okay, so you have to demonstrate you're a parent. Involvement, support, presence. This matters, okay? Documentation of your involvement become really critical when you get in these situations like this, all right? If you haven't established a relationship, you may not have standing to fight for your child, okay? Get in y'all children's life, all right? This applies to fathers who disappear and then resurface and they start demanding rights. So y'all, go missing if you want to. Come back thinking you go have some say. Actions over time build parental rights, not just showing up at the last minute. Okay? If the other parent can show you've been absent, that is powerful evidence. Okay? Like I said, I think it took 10, 11 years till I got equal custody of my younger daughter. I've already had 40% of my son. I'm going back for 50 now. I'm finna get dead down the middle with that one. And this is one of the key factors in that situation. I've never not been present in my daughter's life. Never, ever, ever, ever. Okay? That's how I was able to get equal custody. Not just that, but understanding the best interests and understanding that I touch one of these. I reached the level of every best interest of my child factor there is. But I had to learn some nuances. Like, man, they be on your head. They ask you questions like, all right, do you know the doctor's name? Do you know the teacher's name? Do you know? And I'm gonna be honest with you, I had to learn that. So I felt like I had to be above the average dad, because let's be real. Let's say you're married and in a relationship right now. You know how many dads don't know the damn teacher name? You know how many dads don't know the doctor's name, where their daughter go? Like, let's be honest. Let's be honest. You know how many dads don't know that? So I'm telling y'all, well, at least in Florida, the type of questions that they'll ask you to throw you off. And I'm not saying that's the end all be all, but you need to study those factors in your state. What is the best interest to your child? And make sure you touch those points, and make sure you bring evidence that you touch those points. You understand what I'm saying? Like, stay woke, family. Stay woke. So, okay. Let's get into another case law of what actually protects parents, because I feel like it's a big one. So we're going to get into another case law, and that's going to be Holly versus Adams, 544 SW.2D367, and that's Texas, 1976. So this is the Texas Supreme Court. I know you're like, well, you don't see the U.S. You got to remember SW. Oh man, I got to put up. I may get my editor to put it up on the screen what we went over in the beginning. That those abbreviations and those different and abbreviations that go to what court it is, whether if it's federal, appellate, or just a trial court. And just because you don't see U.S. doesn't mean it's not. It's just different books. So you may have like 3 or 4 different levels at the U.S. that may have different abbreviations. So, but this is still a Texas Supreme Court ruling, even though you don't necessarily hear that U.S. in there. Okay, so I know this from studying and looking it up. It's not like I could tell you off the top of my head, like, as soon as I see a case law, without looking at it, if it's the Supreme Court, by just the abbreviation, if I don't always see US. Okay, so again, it's a lot of states, a lot of different jurisdictions. You need to understand them. Okay. All right. So this next case law is actually a pretty big one on this topic. Which court y'all think it came out of? Trial court, the appellate, or the U.S.? All right. So look, let's get into it. Holly versus Adams, 544 S. W. 2D 367. This is coming out of Texas in 1976, y'all. Okay, so Holly, that's spelled Holley, I believe, versus Adams, Adams. Okay, so this is coming out of the Texas Supreme Court, the big dogs. What was the holding? Okay. They established the Holly factors. Okay. Courts must consider in custody cases, including the acts or omission of the parent, which may indicate that the existing parent child relationship is not a proper one. Okay. So, why is this important? Contemporary documentation of positive parenting defeats allegations of omission. Your records are evidence. Start documenting before a problem arises, okay? Now, if you're going through with the mother of your child or whatever the case may be, you need to start take pictures. Whatever acts that you are doing to be in your child's life, you need to document them, okay? Okay? So let's get into the meat and bones of this Holly case, because like I said, this is Supreme Court one. Y'all know I like to go over the meat and bones of the cases that are relevant to our situations, because a lot of them case laws do not relate to y'all situation. Okay, so the background of this situation, it was a custody dispute, and it ended up going to the Texas Supreme Court. Okay, it ended up requiring that the court analyze the factors that should determine a child's best interest. So this is where this came from back in 1976, y'all. What happened? Okay, the Texas Supreme Court used this case to establish a comprehensive list of factors that judges should consider when determining the best interest of a child. This became the model that many different states adopted or adapted in their own family courts. So, the legal question: what specific factors should courts consider when determining the best interest of a child? All right. The outcome: the court established what's now known as the Holly factors, okay? A checklist that judges use to analyze the best interest. This includes the child's desire. Where does he want to be? If they're old enough, okay? The child's current and future emotional, physical needs, and present and future dangers to the child. The parenting ability of the parties, programs available for help, plans for the child, stability of the home, acts or omissions by the parent showing an improper parent-child relationship, and any excuses for those acts, okay? So this is the list of things that they decided to go off of. These are the factors that will determine custody disputes, because the custody dispute is going to end up being what? Relevant to the best interest of the child. They love telling y'all that. What is the best interest of the child? This is what the best interest of the child are. They list the factors. Go find what factors they are using in your court. This is the baseline, but states adopted this and changed certain things. Yes, this is the baseline, but again, your state will be very specific in the factors, and you need to know them, okay? All right, so let's get into the key points of. All right. This is an actual checklist that the judges use. The judges actually take this checklist out and they use it literally. Okay. Now you know what's being measured. You know the measure of it once you know what the actual factors are. Okay. So child wishes matter if they're old enough. So this usually going to be about 12 or older, where the kid's opinion of where they live matters. So check your state. It's going to be different by states. Stability is on the list. Courts want consistency. They don't want chaos. They don't want you all over the place, okay? They want you consistent. Future needs matter, not just the current situation, okay? They're going to look at how old he's going to be next year, if he's going to middle school, if he's going to be transitioning to high school. The future matters, okay? Parenting abilities are evaluated. Do you know how to parent efficiently? Your plans for the child, all right? What plans do you have? Like education, activities? Are they playing sports? What's the medical care looking like? All that is going to get considered, okay? Act showing improper relationship, allegation, neglect, abuse. They weigh heavily on this. Are there some accusing, what stories that put you in a position where they're saying that you are neglectful to your child? And if so, what actually happened? All that's going to actually weigh into, okay? Excuses are considered the only legitimate ones. You can have an excuse for why your child may have been neglected, or the other party may have felt neglected. I'm not sure what it could be: family emergency, flat tire, babysitter left early, who knows? But again, there are reasons. So let's go over the finalize of this. Holly came out of Texas, okay, in 1976. All right. And this created an actual checklist for the judges that they use for the best interest of the child. It's not subjective. They're very specific factors, okay? Now, one of those factors may have a subjective, like he has a little wiggle room, but they're going to be specific factors to go off of, okay? The child's wishes, stability of each home, parenting abilities, plans for the child's future, any danger to the child, and your conduct as a parent. When you know what's on the checklist, you can build your case to prove your checklist for every box. I literally did this, me, verbatim. When I say verbatim, I mean verbatim. I took every interest of Florida, wrote down the list, and wrote down how I touched base on everything. I had my script ready. I recited them. I went off every factor, every situation that took place in my daughter's life that I felt like I needed to speak to. I had my witnesses ready. I had documentations, pictures. I'm telling you, I was ready. Pro se, no lawyer, no attorney, no nothing. Just me and knowledge. And I went in there and I got split custody of my daughter. All right. So it's coming to an end. The first podcast, Family Court Unfiltered. But let me make sure I got notes out. I know I got the screens up. I got my laptop over here, iPad over here. It's a lot of different case law, and I don't want to give y'all misinformation. I'm not here to give y'all misinformation. You know what I mean? I'm here to try to give y'all what actually works in court. I sat in court one day, okay? Well, before I get to that, let me try to go over the 5 pillars of protection. So we can try to we got to keep our head on swivel. I want it to all come back. I want y'all to take this video, save it, replay it if you need to, take notes. I'm telling you, what I'm giving y'all is actual factual. I ain't giving y'all no fluff. I'm not here to sell y'all dreams. Yes, I do this. I consult, I help parents. No, my services aren't free, but I give out plenty free information. This is free. I just read through. Come on, man. Like, this is a real school right now. We breaking down case law. We going into the merits of it. I'm giving y'all the works, okay? Like, I am treating y'all like clients. All it takes is for one of y'all situations to align with one of these factors or these case laws, and you can utilize it and start studying. Stop coming up with excuses. Stop it. I've been there. I've done that. Excuses are just, they useless. Not when the knowledge is out there. And I'm telling you now, I was doing this well before ChatGPT and all these things came out. Man, I was on Google Scholar, Justia, however you say it, Westlaw. Do you hear me? I was manually typing up I'm talking about document, pages, 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 pages after pages after pages. I'm talking about me typing them. No, nothing to break it down. I was doing years and years ago. Before this got hip, before anybody was out there selling dreams, I was fighting cases. And man, I'm thankful that I learned from a guy who was in a situation like mine and put this information out there. Not even this information. He didn't put this information. He put the information to the point where, bro, you can go study and learn what's going on in your situation. You can go learn your case. You can go learn how to fight back. Everybody on child support or in these situations, listen to me when I tell you, I guarantee you, you can get some form of relief. Now that I will say, well, I'm not going to say I guarantee you. I'm going to say 90% of and that's the Fetty Wap situation with his reduced. That's the dude from Family Matters. All of them guys, bro, y'all can get some relief. It's just motherfuckers don't do nothing. They just let it sit, or they go get a family attorney and think they're going to do what you should be doing. Yes, you can go get an attorney, but bro, shouldn't nobody know your case better than you? Do some research, study your situation, bro. Even if you get an attorney, you need to, should nobody know your story, what's happening in your case more than you. Even if you have a paid attorney. I have students with attorneys. That's okay. You can have an attorney. I'm not telling you not to go get a lawyer. I'm telling you to know what's going on in your situation so you can instruct the person who works for you, which is your lawyer, which is your mouthpiece, who's supposed to be able to handle this for you. Yeah, you can have an attorney, but know your situation, know the rules and regulations so you can guide him into what should be taking place in your situation. You need to be arguing this. You see this law here? Bro, you know how many clients, students I've have come to me who've had attorneys. I'm talking about spent $20,000 on attorneys, and I'm talking about a fraction of that, and I've got them so much more relief than their attorney ever got them in a matter of months because a lot of my work is in the front load. I'm gonna knock out so much in the beginning. Yes, we go prepare for the fight, but y'all gotta know how to prepare in the beginning. The setup is everything. A lot of my parents come to me, they done went and bought a template already from this goofball over here, this goofball over there. Y'all filing all this bullshit. Some of them ain't even motion. They call them, we don't file motion, we file demands, or I file, man, I'm telling you, bro, stop. Oh my God. 5 pillars of protection. Let's get into it. All right, fam, let's go over these 5 pillars, all right? You got documentation, consistency, ability, credibility, and strategic engagement, all right? So, documentation, that's gonna be your own contemporaneous records, all right? That's text messages, emails, calendars, photos with the kids, have timestamps with those photos. All of this needs to be created in real time, okay? You don't want to just start doing this when the litigation starts, all right? So that's your own contemporaneous records. That's continuing documentation as as in real time. Don't just wait till after stuff happens, okay? So then you got consistency. This is going to be the same truthfulness to the CPS as it is to the judge, to the evaluators. Inconsistency against your story is going to kill your credibility. Those inconsistencies in that narrative, when it changes, that is going to destroy your credibility. I got to stay consistent, okay? Stability. So that's the demonstrable evidence of a stable home. That's consistent routines, showing that you're appropriate parenting, homework, how y'all moving. That's going to be included in every best interest factor in just about every state, okay? So stability is a big one. Then you got credibility, all right? Demeanor in court, respect for the process. Are you respecting this process, or are you just showing up with an attitude and you think it's just gonna float on by, okay? The willingness to follow orders, ability to focus on the children, not grievances, okay? They don't want you in there arguing about why this ain't fair, why this is, why this is. You need to be locked in on your child, doing what's best for your child. Then you have strategic engagement, okay? Know when to push and when to comply, all right? Generic constitutional slogans are not going to beat strategy, okay? You need a case-specific strategy, all right? You need to be strategic. You don't have to say yes to everything, but you shouldn't be saying no to everything either, all right, parents? So, need y'all to understand this, man. Y'all rights are real. You just got to know how to utilize them and where you should be using them. I'm going to do a quick court reference again, just to touch y'all up, because y'all need to understand the entire basis of this episode of why I know my rights can get you in trouble in court is based on the different courts that exist, all right? So you got criminal versus family, the standard of proof, all right? So in criminal cases, you need beyond a reasonable doubt. It's going to be at least 95%. Family cases, they use the preponderance amount of evidence. That's just a 51% swing, okay? Need y'all to understand that. The Fifth Amendment, all right? Your silence is protected in criminal court under the Griffin statute or the Griffin case law, okay? Silence cannot be used against you in criminal court, but in family court, it is considered a adverse inference, okay? This is allowed. The case law is Baxter, okay? You being quiet, what do you have to hide? That's how they're going to conceive it in family court, all right? So your attitude. Now, in criminal court, this is limited relevance. You can go in there like John Gotti popping big shit if you want to. I'm talking about don't stand up when they say stand for the judge. All of that. Throw the middle fingers if you want to. You can do whatever you want. Like a boss dog if you in the right and you know you go win. I mean, if you know you're going to lose too. But In family court, your attitude is a major factor on the outcome of your case. Judges will look at your demeanor, your attitude, how you're carrying yourself. Okay? This matters in family court versus how it doesn't in criminal court. Okay? So the exclusionary rule. Illegal evidence is excluded. You're not bringing nothing that was obtained illegally into family court, into criminal court. Now, in family court, there is no exclusionary rule. What you bring for evidence, if you file it properly, it's going to be used as evidence. It's up to the other parent to combat it properly, object, do whatever you need to do, but it will be brought to court if filed properly, okay? All right? Then you have the judicial discretion, okay? Strict procedural rules in criminal court. They have a very strict way of going about things. Sometimes in family court, there's a broad discretion. Even in the best interest, some of those factors are going to have a broad discretion. That's just how it is. And then you got CPS workers or social workers, all right? In criminal court, they're not really involved. They're not coming, that what they say ain't really held. It could be disputed, all of that. Now, in reports, it's going to come up in court evidence in family court. The CPS reports in family court will become evidence, all right? You need to understand that. So, pretty much here, man, the bottom line is we have rights. Y'all have rights. Your rights are real, but strategy is going to beat slogan every time. You go in there with that slogan talk, it's not accurate, okay? It's really not. Parents, I need y'all to lock in. I need y'all to stay focused, okay? This is real. We can win. We could get relief, all right? So I think that pretty much touched all bases. Yeah, parents, lock in. Again, I've been in these situations. I think I wanted to go over something before I wanted to close out. Let me see what it was. See if I skipped over something. Let me see here. Let me see. I just told y'all a personal story about how the best interest factors I literally use verbatim. I have clients in other cases that run into these templates and get in trouble. They get labeled as sovereign movement and fictitious litigants and things of that nature. But testimonies are coming soon. I got a lot of clients. I just had a client. Y'all not gonna see where we stopped at. I stopped the video and had to answer. But a client just coming from another state where her son was taken by the dad under some emergency motion. We filed the proper motion, got that thrown out. The judge said everything revert back to where it was when she had custody. She just went and tried to pick him up. He wouldn't let him get him, called the cops. Now we got to move to file certain orders to get that intact. So it's probably going to be a pickup order where they have to, the sheriff will have to come pick up the child based on the orders of the judge. So we'll work on that. I'll jump on that with my client right after this. But yeah, man, that's gonna be the first episode, man. Okay, episode 1. Why I know my rights will get y'all in trouble. This is Family Court Unfiltered. I'm here for y'all, man. Y'all plug in with me, man. Y'all, we got this. We just gotta stay knowledgeable. We gotta stay accurate with what we're filing. We gotta understand what we're filing, what we're doing, understand the case law. So if this helps you understand family court, if it helped you understand how it actually works, please save this episode and share it with someone that needs it. If you're dealing with a case right now, you need strategic help, that's what my consulting business is for. So y'all reach out if y'all need consult. ChildSupportVictory.com. Y'all can reach me at Child Support Victory pretty much through all Facebook, all of it. Instagram, YouTube. So that's it, man. That's it for episode 1. Y'all stay blessed, parent, and listen. Stay strategic, okay? Y'all have to strategize. Do not take someone boiler template and just utilize it without reading it, seeing if it matches your fact pattern. So, Child Support Victory, all right, presents Family Court Unfiltered, episode 1, Why I Know My Rights Will Get You in Trouble in Family Court. Stay blessed, parents. I hope to see y'all on many, many more. This is just the beginning. Y'all stay with me, okay?